legal commentator Gabriel Malor on why the Fifth Circuit withdrew its recent silencer decision and what comes next. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also a CNN contributor and the founder of thereload.com, where you can head over and sign up for our free newsletter today if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on hard news and analysis. This week, we are talking about a pretty fascinating situation in the Fifth Circuit dealing with challenge to the National Firearms Act's regulations on silencers and a withdrawn opinion, something you do not see very often in the federal courts. And to do that, we have back with us a federal litigator himself and legal commentator, Gabriel Malor. Thank you so much for joining us again this time around.
Hey, Stephen. Good to be here.
And for people who might not know you or haven't seen you on the show before, can you just give them a little bit of background about yourself?
Yeah, so I'm an appellate litigator. I work almost exclusively in the federal courts. I have for 15 years now. I've also been a political and a legal commentator. So if you end up Googling my name, you'll see me around a lot on the internet. I'm also thoroughly addicted to social media. So you can also find me on Blue Sky, where I'm at gabrielmalor.bsky.social.
And you've written for a number of publications.
I have. I've written for National Review, The Bulwark. I think I wrote a piece for the Dispatch. I've written for USA Today, New York Post, New York Daily News, so a bunch of places. I've been around a long time.
All over. You've been all over the place. And I'm a Dispatch contributor. So are you a contributor over there now?
A couple of pieces.
Yes. Good. Great publication, by the way. Free shout out to the Dispatch. But so let's start off here. How often do you see a court withdraw one of their opinions?
Maybe a couple of times a year. It's not really that often. Most cases are, one and done. The court has issued its opinion. Whoever loses, has the opportunity to appeal or to seek further review from the court. But even then, a lot of people, if you lost, you've lost, and you don't want to pay your lawyers anymore. So this was kind of unusual, just the way the case shook out. This is a criminal case. Case
called U.S. v. Peterson, right?
U.S. v. Peterson. It's about silencers or suppressors, if you prefer. Mm-hmm. And the Fifth Circuit came out and just point blank said suppressors are not arms within the meaning of the Second Amendment, and so they're not covered at all.
Right.
I think some people were kind of disappointed with that outcome.
Certainly, yes. A lot of people in the gun rights community were very disappointed with that ruling, especially from. This Fifth Circuit is the most conservative. It has a reputation for being the most conservative circuit in the country. And
right.
I believe
one of the judges who wrote the judge who wrote this opinion is very conservative. Mm-hmm. So it was a little surprising. They didn't even get further into is there a historical tradition of regulation of this sort of thing? The second Bruin step. They just point blank and said, hey, suppressors are not covered. The end. Yeah. Which was kind of they didn't really get into they're not arms.
Yeah. And so obviously going from that opinion and then having them withdraw it, especially the circumstances that they did, which we'll get into, has a lot of people buzzing about what it might mean. And we will certainly get deep into what it could mean and maybe some of the things where I feel like there's some misconceptions out there about what the arguments are at play here and what's likely to happen. But first off, let's just talk a little bit about what this case is about and what the initial holding was.
Sure. So this was, like I said, it's a criminal case out of Louisiana. And a guy was under investigation by the ATF. And when they searched his house, they found a suppressor. And the interesting thing about this suppressor was it's homemade. So there's some other arguments later on that we could talk about, but he made it himself. He didn't buy it from a manufacturer. It didn't ever cross state lines. But they found it, and it is unlawful in this country to possess an unregistered silencer.
Yeah, so it's actually not so much that he made it himself that's the problem. It's you can do that legally.
He didn't register it. You have to register it. It has to have a serial number. You've got to do some training, and I think you have to pay a tax.
Yeah,
but he didn't do that. He just made it, and it was in his safe, and they found it when they were poking around his house.
And so that's a National Firearms Act violation.
Mm-hmm. Yeah. And like you're saying, he could have avoided all this if he registered it, but of course he doesn't want to register it. He wants to make it and keep it in his house for himself. So
Which
anyways,
probably feel the same way, but yeah.
Worked its way through the normal course. But one of the arguments he made in defending his case was, hey, the Second Amendment protects my right to own a suppressor. And then the district court disagreed and he was convicted. And of course, then he appealed, as is his right, to the Fifth Circuit. This was last year. So this was before President Trump was reelected. Mm-hmm. And it was fully briefed and argued by December of last year. And the argument that DOJ made was the argument that prevailed was that silencers are not arms. And so they don't come under the Second Amendment at all. And they can regulate it essentially however they want, consistent with, other constitutional provisions, due process, and so on and so forth.
Right. And they got pretty into the weeds on that, right? This opinion they issued was not, a cursory thing. It wasn't a couple pages. They delved into the idea that suppressors are arms or they're protected by the Second Amendment, right? They actually examined this issue. It wasn't,
it wasn't cursory.
It wasn't a cursory.
Well, so Peterson was suggesting, look, the suppressor becomes an integral part of a firearm when it's put on. And so therefore it counts. It's covered in some way by the Second Amendment because it's attached to the firearm itself. So that's what they kind of looked at it and said, well, yes and no, but mostly no. Just because you can attach something to a gun doesn't make it a gun itself, right? One of the things they discussed was, a suppressor isn't itself a weapon. They cut this down almost to a fundamental level and said, what does the word arms mean in the Second Amendment? And they said, well, an arm is a usable firearm or a bearable firearm. And then they asked, well, is a suppressor itself a bearable firearm? And the answer is obviously no, right? It doesn't shoot anything on its own. It doesn't do anything on its own. It's only a weapon insofar as you can throw it really hard at somebody. But that isn't what the founders meant by arms in the Second Amendment. And so that was their thing was, look, we don't have to do the Bruin analysis. We don't have to even really think about that because a suppressor in itself isn't a firearm.
Right, but I think they do cite to Bruin, right? Which is just Bruin.
Yeah, they mentioned essentially they're suggesting we don't need to get to the first or the second step. The first step about Bruin is, are you part of the people covered by the Second Amendment? And they sort of assume it. It's because, yeah, sure, Peterson he wasn't convicted of a crime before this. You're part of the people. But even more fundamentally, the Second Amendment applies to the right to keep and bear arms, not arms and other things, except for some things we can get into. And that's one of the arguments that has been raised now in the following the opinion. So the opinion came out in February. And then Peterson filed what's called a petition for rehearing and also a petition for rehearing in bank. And the first is where it goes back to the same panel and says, hey, panel, I need you to rethink this. And the second one, it goes to the full circuit and says, hey, this is so important and the circuit precedent is so wrong. We need the whole court to fix its own mess. And so he filed it, essentially making the same arguments he made before. The court then ordered the government to reply because these are so disfavored, you're not even allowed to reply unless the court tells you to reply. Usually when somebody files something against you in court, you think immediately, oh, I got to call my lawyer. He needs to file something back. For a petition for rehearing like this, the rule is you're not allowed to file until the court looks at it and says, well, this is interesting enough. Okay, maybe we should hear from the other side before we rule, because usually they just deny them as a matter of course. But this time they ordered the federal government to reply, and so they filed an opposition saying, we agree with the court's decision. We think they got it right. It's in line with all of the other circuits. This isn't a question we think the Supreme Court is going to be interested in, so therefore you should reject this petition for rehearing.
And the timing on that is important, right? When this
so the court decision came out in February. The petition for rehearing came out, I think, at the end of February. This came out maybe 3 weeks later because you've only got 14 days to respond. This came out on March 17th. And the tone, I've got to say, for a rehearing petition or an opposition to a rehearing what the federal government filed, I mean, they almost mock Peterson and his argument. They talk about, there's this line in here, a pillow or a plastic soda bottle taped to the barrel of a firearm can also reduce the noise from the discharge of a bullet. Do these items too become weapons when attached to a gun? I mean, this mocking tone where they're asking these rhetorical questions where I read this brief, and I'm an appellate litigator. And I don't do rhetorical questions in briefs. And when I see them, I kind of think, I don't know if I like that. This sounds to me like something maybe you could hand this up in front of a judge or a jury, or like, this is trial court stuff where you're asking, how could a pillow be a weapon, protect an arm under the, like, okay, yeah, we get it, tone it down. Like, but to me, it was kind of amazing, this very strident opposition to rehearing, telling the court, you don't need to take this case up again. We have already won. Just make it go away. That's what the federal government said. And
because DOJ from the beginning here, during the Biden administration, was when the actual trial happened, and they argued, against Peterson's positions. The court sided with DOJ, and then in this rehearing, even though there had been a changeover, it was the very early days.
It was March, but the president had already at that point issued his executive order telling DOJ to reevaluate its Second Amendment cases,
and so it looked at that point. Yeah, it looked at that point like they weren't going to change their minds. They weren't going to change their position on this particular idea, this particular case. And so it seemed like, well, maybe either it was going to go en banc because the full Fifth Circuit, disagreed with the panel, perhaps, or it was just going to go away, and that would be the end of the case, right? But that's not how it played out, right?
No. A few weeks later, actually, almost a month later, in May, the federal government came back and said, you know what? We've changed our minds, and we think that suppressors are protected by the Second Amendment. And they filed a not very long supplemental response, and it was itself remarkable because not only have they now completely reversed their position that they had argued through the entire case, it's not really based on much citation to precedent. Especially Second Amendment, but we're looking for our Second Amendment cases that would stand for the proposition suppressors are protected under the Second Amendment. Unfortunately, there are no cases. All the circuits to address the question, which are 3, have said no. Some district courts all over the country have addressed the question, and they said no. So DOJ in its new filing does a kind of a weird, they're like, well, we think that firearm accessories could be protected to the extent they're useful, or that to facilitate is one of the words they use, useful and facilitate the use of a firearm. Yeah, and then they have a whole...
let me read one excerpt from their opinion, because actually this will be important too when we talk about some of the way this has been covered or talked about, I think, because there's a little bit some misunderstandings out there about what DOJ is actually arguing here, because technically they're not arguing that silencers or suppressors are arms, right? Instead they say this, quote, they list out basically why suppressors are useful, essentially. They make people more accurate when they're firing. They reduce recoil. They reduce the sound of gunfire, which makes it easier to hunt or to target practice. And so they say, quote, all these practical benefits demonstrate that suppressors facilitate the constitutional right to keep and bear arms. Accordingly, restrictions on suppressors impose a burden on using firearms that implicates the Second Amendment. So they're sort of getting at this idea that silencers and suppressors, they're not arms themselves. They don't fit that definition that was laid out in Heller that comes from Blackstone, I believe, the legal dictionary from the founding era, because they're not weapons in and of themselves, but they facilitate the use of arms, and they make them more effective. And so they enjoy some sort of Second Amendment protection. That's more or less what they're arguing here, right? That's
their argument. And the most interesting thing about it to me is that that's a policy argument. It doesn't seem to me why that would be compelled by the text of the Constitution, which, as we say these days in my line of work, we're all textualists now. But that's the argument the government made in a very brief section of their response, just saying, okay, we do think they're covered. And then they urged the court to go beyond what it did before and apply Bruin and look to, can we regulate these things in the way that they do, right? Putting a tax on it, requiring registration.
And this is another kind of interesting twist, right? Because they say, all right, well, we're changing our view on whether or not silencers are protected by the Second Amendment. Because initially DOJ, under the Obama administration, and even early on in this new Trump administration, said, no, these aren't protected at all. They're not arms. They're not protected. And as you mentioned, they even kind of mocked the idea that they would be protected. And then they said, all right, well, we changed our mind on that point. They are protected by the Second Amendment. But
but not enough that it matters to the outcome here.
Yeah.
Which is clever, but I mean, you can see the doctrinal expansion there, right? Now, it's not just arms we can look at, it's things that are useful to arms, that facilitate the use of arms, which is certainly a change in the federal government's position.
It's fascinating, though, too, because, and we've written about this. Jake Fogelman, the contributing writer at the Reload, has talked about how the DOJ has been fairly aggressive at going after states, especially Democratic-run states, over their gun laws and gun restrictions, but they've been much less aggressive about going after federal laws, and they've been much more lenient in the idea that these federal laws violate the Second Amendment. And this is maybe another example of that, because I think the practical implication of this argument is that the federal law, the Federal National Firearms Act, if you adopt the DOJ's thinking here in this second letter that they've sent, would be fine. Like, it's not, yes, silencers are protected by the Second Amendment, but the National Firearms Act is only a tax on them, a tax and registration scheme, and it's not a total ban, and they don't have, silencers aren't part of the core right necessarily of the Second Amendment, so they don't enjoy as much protection as kind of the point they're getting at, I think, in the brief a little bit. And so the federal law would withstand scrutiny, but there are a number of states that outright ban.
Do a full ban, yeah.
Yeah, and so the implication there would be maybe some of these state laws in some of these blue states aren't constitutional, but the federal law is.
Yes,
right?
Yeah, but that is the legal consequence that would follow if the court were to embrace the response, or the second response, the supplemental response.
And you'd have to get up to like the Supreme Court for that to matter across the country. Obviously, the Fifth Circuit, there aren't any silencer bans in the Fifth Circuit, but outside of the NFA.
Right. Well, if the Fifth Circuit were to change its mind, so to finish the story, after DOJ filed its second response, the court withdrew its opinion, and then also mooted the request for rehearing en banc. So they're starting from the position now, okay, they need to decide whether they're going to rehear the case. They can either rehear the case, they can deny the motion to rehear, and then reissue an opinion. If they rehear the case, it gets rebriefed and it gets re-argued. So the administration would have the opportunity to more fully flesh out these ideas than they did in just their response.
What usually happens in a situation like that, in your experience, like when they've withdrawn an opinion and
the typical thing that happens in a case like this is the court ultimately denies, I mean, just because it's common and it's easy, they will say, we've heard enough. They deny the motion for rehearing, but then they issue a new opinion that addresses whatever it was that the parties were getting at. Just so that, okay, we've covered what the parties want to argue about, and then the parties will have another opportunity if they want to seek further review, either from rehearing en banc or from the Supreme Court.
Okay,
but that's just because it's the easy thing. At this point, remember, I mean, these judges have been with this case for at least a year. They are familiar with the facts. They're familiar with the law. And a petition for reopening or for rehearing, I mean, it's unusual to see them granted. It happens.
DOJ doesn't want them. DOJ doesn't want it to go up to the full Fifth Circuit, right? They don't want an en banc hearing.
I'm not sure that. Well, they did oppose it originally, and now it's moot.
Do they not have a position on it in the new filing? I guess
I don't know if they took a position on the new motion.
Okay,
but it is moot since the court withdrew the opinion. There's no longer any question of rehearing en banc.
Because the DOJ doesn't want like a different outcome. They just want a different way of.
They just want a different legal precedent.
Yeah.
But to be clear, if the Fifth Circuit were to agree with the government now on its new position, that would create a circuit split. And it would be up to Peterson as the losing party. If he wanted, he could seek certiorari from the Supreme Court and say, hey, you guys should take up this case because now there's a circuit split between the 5th, the 4th, the 10th, and the 9th. Right. That's fairly compelling. I would be interested. I'm sure the court's been wishy-washy. Sometimes they take them, sometimes they don't. I'd give that fair. I'd say I'd probably get further review if there was a circuit split. If there's no circuit split, then it's fine.
Well, because this could all be moot eventually, relatively soon anyway, depending on what the Senate does, or what Congress does with this NFA repeal, partial repeal. But although I don't know how that would affect current cases anyway. like this one. I assume it wouldn't have it. Do you know, would it have an impact if the NFA delists, or if Congress decides to delist silencers and suppressors from the NFA in this new bill which is how the text currently reads? We don't actually. There may be some decisions on this between when we're filming and when the episode goes out. Actually, because we're still waiting on Senate parliamentarian and all this stuff to happen. But if that gets through, if they take silencer out of the definition of things that are covered under the National Firearms Act, would it make cases like this go away?
None of the convictions that currently stand, unless Congress took the additional step and said, "Oh, all those people could apply to have their convictions vacated," which I don't think I've seen that language anywhere.
No,
but for future cases, then obviously you can't. Once the statute is changed, then from then moving forward, you can't prosecute in those cases.
Got it. So this case will still matter.
This case will still matter. I mean, he has
regardless.
a conviction right now. He has a conviction and a sentence. So
it's good to
he needs
know.
an answer, and he will get an answer. But I think the answer is going to be the same that he got previously, to be honest with you.
Right. So let's get into that, because what I've heard a lot of from like gun rights activists and from some legal commentators, I think Mark Smith, he runs Four Boxes Diner. He's been on our show a couple of times. He's a Supreme Court bar member, and he's written a lot of books about the Second Amendment. So like he comments on this stuff a lot, right? He's a legal commentator as well. He's pretty convinced that, and I've seen a lot of gun rights activists take this view, that the panel here is likely to reverse themselves and actually find that silencers are protected arms. Now, I think he argues that they'll ultimately end up the same conclusion that DOJ did, which is that the NFA is still constitutional under Bruin because it's not a total ban, it's a tax. So, some of these other reasons that DOJ listed out. But, that seems to be a pretty popular idea right now among gun rights activists looking at this move by this panel. And what do you think of that? What is that?
So I
reasonable?
Certainly don't think that the panel under any circumstances is going to suggest that suppressors are covered arms.
Okay.
I think there's slightly more chance, but a very slight chance, that they might buy into this facilitation of arms argument, because there is some doctrinal case law that's in the same area, and a lot of the amici have filed briefs pointing out, you can't do a total ban on, for example, long gun ammunition, even though it doesn't say the right to keep and bear arms and ammunition.
There's also
that would make the arms useless. I mean,
right.
A long gun without a bullet is just an ugly club.
And there's cases that say like you can't ban shooting ranges outright.
Right, you got to be able to train with them. Yeah.
So there's always courts have found some sort of penumbra.
The extension here is like a suppressor is like that sort of thing. It's something that facilitates. The problem with that argument, and it's one that this panel previously addressed, basically, sort of, is that there's a difference between things that are necessary for the use of a gun and things that are, just nice to have, which is suppressor is not necessary for the operation of a gun. It works the same whether the suppressor is screwed on the front of it or not. You're asking this panel to stretch to say, okay, we decide that this facilitates the use of the weapon enough that we can consider it protected. And I think that is a stretch, especially because they were so clear before. I mean, they were firm. In the February opinion, they are point blank, look, these are not covered. And so we do not have to take another step down the Bruin path.
Yeah. Well,
and
so I guess the counter argument, just to get in the counter argument real quick, this, as I understand it at least, is that that's if you ban silencers, you're banning a class of firearms, which is silenced or suppressed firearms.
Suppressed firearms.
That's sort of how I've seen it articulated, at least, as to why it would violate the Second Amendment. You're banning a whole class of firearms, which would be suppressed firearms. I don't know. I don't think they addressed that idea necessarily in this argument, but that's it also goes back to something you've seen in some of these magazine ban cases, right? Where you get some similar conclusions from some courts, including the Ninth Circuit, right? Where they're saying, well, magazines that hold more than 10 rounds, they're so-called high capacity magazines, they're not necessary to the function of firearms. They're not arms themselves because you could still use, a magazine that doesn't hold more than 10 rounds. And, people, obviously there's some debate over like, where do you draw the line on that? There was, one of the Ninth Circuit judges got a lot of attention for making a video dissent in the magazine case out in the Ninth Circuit, where he got into this question pretty deep. Like, well, technically you don't need a particularly nice trigger for a gun to work. So can you ban all the triggers other than a bare piece of metal sticking? How does that? Where do you draw the line on what is and isn't necessary to the function of a gun? I guess is sort of the point you'll see in opposition to this.
Sure,
this
and that actually returns to DOJ's prior position or argument or taunting, really, that how many decibels does it need to reduce to be covered under the Second Amendment? Yeah. And you end up with this line drawing thing, whereas when is a suppressor suppressing enough, right? That was the example they gave. Oh, if I tape a pillow to my gun, sure, it's reducing the decibels somewhat, but obviously, that's not a suppressor. But
so you can take it either way.
It's the same thing what you're talking about with the high capacity magazine bans. It's a matter of degree. What is enough to be protected? And I kind of don't like that type of reasoning for that reason, because it is arbitrary, because at that point we are just arbitrarily line drawing. And I don't know that the Constitution necessarily does that in an arbitrary fashion, because the next step under Bruin and Rahimi, well, then we'd look back and say, okay, well, what were the others, as a group, suppressed firearms? Would the founders have recognized suppressed firearms as a distinct group from arms? Within or under, and I'm not sure that they would, or that there's much historical support for that. But again, and then beyond that, right, because the argument that the government is now making, their new argument is, we don't really need to consider the suppressed firearms part, because as long as they're facilitating the use, then we can go and say, we're only taxing them, we're only requiring registration, this is less than a full ban, and because it's less than a full ban, we can basically do all these things. Yeah,
they kind of get into an interest balancing situation there is what they
which is what Justice Thomas said not to do. So there shouldn't be an interest balancing.
They kind of argue that because it's not the core part of the what's protected by the Second Amendment, you can kind of do interest balancing.
That is their new policy argument, right? That suppressors are good because they're valuable and useful in these ways. That is absolutely interest balancing. And I don't know where the Supreme Court would go with it these days.
Yeah, to me, when I look at this situation, I have been a little bit confused as to why people seem so confident that they're going to reverse themselves on the idea that suppressors are arms, because one, DOJ doesn't argue that in the brief, right? And two, it wasn't like some of these lower court cases on the Second Amendment where they uphold the government's law, you'll see some pretty weak reasoning, right? Like sometimes you'll just see them point to Heller and say, well, Heller, like a lot of felon in possession cases are pretty lazy on the judge's part. They'll just say, well, Heller has this dicta about not questioning felon in possession bans, so therefore felon in possession ban is fine. We don't have to even do any of the Bruin tests, really. And I could see in a case like that where, the judge has room to do an actual analysis and changes their mind or something. But this case, like these judges got pretty deep into the arms question. And, I don't see anything in this opinion that makes me think they didn't understand the arguments at play. I don't see any really new arguments here, certainly not on the arms question, whether they're arms. And so it'd be very strange to me if they just decided to reverse themselves on that point, especially when DOJ is not even asking them.
It's not really wanting. Yeah, I agree for a couple of reasons. First of all, because their original decision is very well reasoned, right? And second of all, making that changing that part of the decision would create the circuit split, which I think they would be reluctant to. And then finally, judges, sure, some courts overturn prior decisions, but not usually the same judges making the same decision.
Right.
Right.
So one of these judges is the chief judge of the Fifth Circuit, right?
Yes, but that rotates.
Okay.
That's not
Yeah,
true.
that struck me as like maybe he's not inclined to just reverse
Like,
himself.
literally for them to come back in, February, they're not arms. Now we're here in the summer, and they're like, okay, we decided we were wrong. We've changed our mind.
Right.
I just don't see that. I mean, it's too flimsy, especially the reasoning we've had so far.
Yeah.
I just don't see it coming from this particular panel, because then it sort of gives the lie to the idea. I mean, we expect reasoned decisions from our judges, right? Even when we disagree with the court, the court's trying to explain its reasons and tell us, well, most of the time the courts are explaining their reasons and explaining what they're doing. And so we could say, okay, well, I can disagree, but I guess, you've got some reasoning, and that's the rule of law. For them to come out and say, hey, we were wrong, we've changed our minds, like,
Yeah.
just because
It's not like there's some new facts that came to light, or
there's no new facts, and there's almost no new law. Like this, it's one thing when the Supreme Court changes a case and said, oh, these courts are getting it wrong, and then all the lower courts readjust their thinking and said, okay, well, we've heard to do different. Or it's not like Congress came along and changed the text of the law. Yeah, anyways.
Yeah, not yet.
But so literally, I mean, we're asking them to change their minds on the same facts, on the same law. Yeah. I don't really see it.
And that's so then I was pretty puzzled as to why they even decided to, remove the opinion in the first place. And once I read the DOJ brief a little closer and the opinion a little closer, I did, you mentioned earlier that they do address to some degree this idea of silencers not being arms, but being facilitators of the right to keep and bear arms, and therefore enjoying some level of Second Amendment protection, right? Because that's what DOJ is arguing. And they talk about this a little bit. They talk about, as I mentioned earlier, the case Zell, which is struck down Chicago's ban on gun ranges. Although, I still don't think they have any gun ranges in Chicago all these years later, by the way. But at least in principle, legally, they aren't allowed to just ban outright gun ranges. There's some, basically the idea is you need to be able to exercise the right to keep and bear arms by practicing at a facility like a gun range. Is sort of the Second Amendment protects that to some degree, and so they did address that a little bit. I'll just read it briefly here, and I should mention too, like the reason that it struck me as, okay, I can maybe see the logic for why they've decided to go this route of potentially reissuing an opinion, is that while they do address this, and I should find, apologies here, I've missed the page that I was on, but basically, while they do address it, they only do it in like 2 paragraphs, and they essentially say they fall back to this idea that, as you mentioned earlier, that suppressors aren't actually necessary to the function of the gun, because Peterson makes a couple arguments here. One, he talks about accoutrements, right, which is sort of like the things that aren't the arms themselves, but would be considered protected as well. And the court argued that those only applied to stuff that was necessary for the gun to function, like gunpowder or lead shot, and silencers just aren't that. Even though Peterson said, well, the bullet has to travel through the silencer as part of the operation of the gun for suppressed firearms. They said, the gas collection device doesn't actually facilitate the functioning of the firearm. And so that's why they said it doesn't enjoy any Second Amendment protections. Right? Did I get that? Read that or regurgitate that correctly? Because I have sadly missed the page that I was looking at. But
yes, and now that the federal government has changed its mind about the level of review this is going to get, it's like, okay, well, it's protected, and we need to apply Bruin and look at whether there's a historical tradition of regulating firearms that includes, for example, registration and taxation. Mm-hmm. They're saying, hey, it would be okay with the government if you did rehear this case.
Yeah, but it feels like there's room for them to extrapolate on this particular point.
On that point. The reason I think they withdrew the opinion, the reason that we're going to see either a new opinion from them or further review, is something called the party presentation principle. And this is the idea in federal litigation that the courts rely on the parties to present the issues for review, so that the courts, in the role of neutral arbiters, can rule on the matters the parties present. And so in this case, even though the government is very late, considering this case was already over, all but over, is saying, okay, well, the federal government has a new position. Maybe we need to write a little bit more about this and why we agree or disagree.
Yeah. And I was looking at the wrong document earlier, so I did find the quote I was looking for here. And they say, addressing the accoutrements argument, they conclude with, as the government aptly explains, an operable firearm will work perfectly well without a suppressor, but a suppressor will not transform an inoperable firearm into an operable one. This same point dispenses with Peterson's other scope-based argument. He cites Zell v. City of Chicago, where the Seventh Circuit held that the right to possess firearms for protection implies a corresponding right to acquire and maintain proficiency in their use. The core right, the court reasoned, wouldn't mean much without the training and practice that make it effective, so it concluded that Chicago's citywide firing range ban was unlikely to pass Second Amendment muster. Even if we were to follow Ezell, it can hardly be said that suppressor regulation has rendered the right to bear arms meaningless. The use of a suppressor, as we noted above, is not necessary to the use of a firearm, so it is not protected by the plain text of the Second Amendment. The Second Amendment, therefore, is not offended by the NFA regulations, so we affirm the district court's denial of Peterson's motion to dismiss. So that's where they address the new argument from the DOJ, in my mind. It's a similar argument, right? But they only spend this one paragraph on it, so maybe they want to give that more.
Explain a little more why that policy argument is going to be insufficient. And by policy argument, I mean the idea that the suppressors are in fact useful. They protect hearing, they facilitate communication, which is important for safety. I will say that paragraph is, 6 or 7 sentences long, but they repeat the hearing thing 4 times. So it seems like they had trouble coming up with their own policy reasons itself. But
that is the main purpose of a suppressor.
Reduce the sound. I mean,
reduce the sound. Yes,
reduce the sound of it. So, but it was obviously persuasive enough. It was obviously persuasive enough for the court to say, okay, well, we'll withdraw the opinion and give it some more thought.
Do you think there's any concern from the panel that maybe, obviously courts don't like getting overruled, right? Maybe they were worried that if they don't do more to address the DOJ's brief, now that the DOJ just changed its mind and you're in the most conservative circuit in the country, that the full court would take up this case and then reverse them. Is there any sort of judicial politics at play, perhaps?
Well, I have no inside knowledge about this, but right. I think that's exactly what's happening here, is that the panel judges, they want to take a stab at this argument before the full court, the en banc court, gets a chance.
Okay.
So they can sort of that way kind of maybe however they shake out, they can sort of frame this new issue that the federal government before it goes to the full Fifth Circuit.
Right.
And if, I have no inside knowledge. I have no idea if that's what was on their minds at all, but it wouldn't surprise me. There are certainly some judges on the full court who would find the government's new argument very persuasive. And I think they would definitely write about it. I don't know if there's a majority of them, but majority of the Fifth that would go for it. There's certainly enough to write dissents, and so they may have said, okay, well, we need to address this argument now that it's out there. We need to say something before the full court gets a chance.
Okay, so that makes a lot of sense to me. The DOJ changed its position. It's a position that probably will have at least some sympathy on the en banc panel of the Fifth Circuit at this point, I would imagine. And this lower court didn't, while they did address it to some degree, it didn't flesh out they could probably say a lot more about it.
Yeah, and their treatment of it too was as treating it as Peterson's failed arguments.
Right.
And not whether, the federal government now is suggesting this too. We really need to say, do we agree with them? Because on that issue now, there's sort of some agreement between Peterson and the government. I mean, the government, of course, still thinks he should be convicted, but
right.
As an intermediate step, the parties are a lot closer together than they were previously.
Yeah. And, government judges, there tend to be some deference towards the government in these areas, right? Like, I don't know. Do you think they might take it? Sounds like you think they might take the argument more seriously this time around as well.
Yes, only because, like I said, the courts rely on the parties to present their issues. And here, even though it comes so late, extraordinarily late, and that's the thing I think maybe people are more excited about this than they should be. If this had come up earlier, right, for example, if the federal government had never filed that first response to en banc, where they essentially mock Peterson before changing their position, maybe this wouldn't seem so shocking. But the fact that the U.S. Attorney's Office in Louisiana, they were just steady the course. Just, okay, no, you're still right, judges. This guy's still an idiot. We don't have to listen to his arguments. Just go away. And then this huge reversal. That's why everyone's excited, because, oh my gosh, this is a huge reversal. It's crazy. But the fact that the federal government has reversed on it, I mean, we had a change in government, and maybe they didn't get around to, maybe they didn't really notice it or think about it. Maybe somebody at Maine Justice, maybe somebody at the White House saw it and suddenly said, oh, wait, no, we want to make a change in our position. And heck, we got a new federal government, so let's see what the court says.
All right, well, that all makes sense to me. I think they come out with their own another opinion, and they reject this new line of reasoning, because I just don't, it seems more likely that they would change their mind here because they didn't spend as much time thinking or talking about this in the first time. I don't see any way that they're going to change themselves on whether silencers or arms, but maybe they'll say they do enjoy some.
Right.
We were wrong about the idea that they don't enjoy any Second Amendment protection, because it's not an unreasonable argument. It might not be based in any Supreme Court precedent or anything at this point, but it's not an absurd argument to say that they enjoy some level of Second Amendment protection, perhaps.
Because then, it's an interesting position, because federally, at the moment, it's just tax and registration. Right. But some states want to ban suppressors outright. Right. So that would create this doctrinal case law where they can say things like, oh, your state ban is unconstitutional, but our federal regulation is fine. Yeah.
And that seems to be what they're aiming at DOJ right now. And also, it's not an unreasonable thing to be excited about if you're a gun rights advocate, that could become precedent, and certainly that it's already DOJ policy or position. Because a lot of them want to see those state level bans, struck down. I still think that the best route for that is probably legislation and not litigation. But because of the inherent issues we talked about in here with this, the way the Supreme Court has defined arms does make it harder to view silencers as part of that collection. Now, this other argument about sort of the umbrella of the Second Amendment protecting them is interesting, but weaker, right, than if they were just arms. But, in the end, it'll be interesting to see what they do. Like you said, this doesn't happen very often. I've never seen it happen before. I only follow the gun cases, though. So pretty fascinating situation, right? Almost a legal mystery that we're watching here.
Yes, and likely to provide continued interest, no matter which way they shake out, because certainly defendant here, he's got everyone's attention now.
And he's got everything on the line.
He's got everything on the line because he's been convicted. So wouldn't surprise me to see him seeking further review from the Supreme Court. Yeah.
And it could get up there if they do. Maybe they will reverse themselves completely. For the reasons we outlined, I think it's not likely. But if they did, it would put this on the fast track, perhaps, to the Supreme Court, which would be all the more interesting. But by the way, any idea on timetable here for when they've withdrawn this opinion? Do we have any clue on when they might issue a new one?
No, the Fifth Circuit, I can say relatively, the Fifth Circuit is fast. Some circuits take months and months and months. I had a Ninth Circuit case that took like 5 years. I don't think that's going to be the issue here. This is the Fifth Circuit. They move pretty fast. So I suspect before the end of summer, maybe before the end, it could be before the end of June, for all I know, we will see further action from this panel. I don't think they're going to sit on it for very long.
Well, a lot of action in the NFA world these days. So we're going to keep on top of all that. But we appreciate you coming back on the show and giving us your insight here. If people want to follow your writings and your work, where can they do that?
Well, the best place to find me these days is over at Blue Sky, Gabriel Malor. I'm doing a lot of legal coverage like I have everywhere. And as the Supreme Court term wraps up, I'll probably be writing a lot more about the Supreme Court cases. Actually, by the time this podcast comes out, we'll be at the end of the term. So come find me on Blue Sky.
They already got through all the gun cases. We talked about that with the editor of the SCOTUS blog a couple weeks back, but a lot of other massive cases with a lot of huge implications still to come, and they're issuing them all at once because the Supreme Court does not care about your deadlines if you are a writer. So they're doing them all at once on Friday. So by the time this comes out, everyone will already know what they've done in that area, but we will probably still have this legal mystery we discussed hanging out there for everyone to puzzle through and figure out and wait to see what the Fifth Circuit does. But all right, well, we appreciate you doing this, and maybe when they make a decision, we have you back on, or certainly for another federal legal story in the future at the very least. But
I'd love that. Thanks for having me.
yes, absolutely. Thanks for coming on. That is all we've got for you guys this week. You can head over to thereload.com and sign up for our free newsletter if you want to keep up to date with what's going on with guns in America, and buy a membership if you want to support the kind of reporting that we do here. It's how we fund all of this. So that's all we've got for you guys this week. We will see you again real soon.